Welcome to the Vendor Responsibility Question and Answer session. In order to ensure we're providing the information that you need for your day-to-day reviews, a survey was sent to the agencies requesting vendor questions that you may have. This session will provide answers to the questions that you provided to the VendRep team. Here you can see the topics that we'll be covering today. The questions were grouped together regarding similar topics. If a question did not fit one of those topics, it will be addressed in the Miscellaneous section. Remember, if you have additional questions, you can submit them during the presentation for the live Q&A following this training. These are some of the terms that you will hear discussed during today's session. When we say vendor, we're referring to the entity that is contracting with New York State. Agency refers to the state contracting entity. Contract is the transaction that you're working on. FEIN, EIN, or TIN refer to the Federal Employer Identification Number. We use these terms interchangeably. No matter which way it is used, it refers to the Federal Employer ID Number. Vendor ID gets assigned for both use in SFS and the VendRep system. Certify applies to the vendor, not to OSC or the agency. And now I will turn things over to Jamie to discuss the vendor review process.
Thank you, Renee. Our first section is going to be the vendor review process section, which brings us to our first question. Can you provide the steps that OSC takes to determine vendor responsibility? So the first thing to make note of is that we at OSC don't actually determine vendor responsibility. The state contracting entity determines that themselves, and we do our own review to see if we concur with their findings. This includes checking all the required VR documents in addition to other web-based resources. We look for certified and current profiles and questionnaires, along with the appropriate workers' compensation and disability insurance proofs where applicable. It's also important to remember that responsibility should not be reviewed just for the vendor themselves, but also for key employees and officers. And that brings us to our next question, which states, what is the look-back period for issues when completing the vendor responsibility profile? So the look-back period guidelines we go by on profiles are the same that are outlined on the questionnaires. Bankruptcies go back 7 years, government audits go back 3 years, and all remaining issues go back 5 years. There are two important things to remember, however. First, you may always look back further if you wish to do a more thorough review. And second, the look-back periods are based on the resolution of the issue and not the original occurrence. So for example, if a vendor was involved in a lawsuit due to an event that occurred in 2005, but a settlement wasn't reached until 2018, it would fall within the 5-year look-back period and be valid for assessment. Our third question in this section asks, what qualifies a vendor to be deemed non-responsible? And then who determines that a finding on a vendor would result in that vendor being non-responsible and thus cause an agency to move on to the next eligible vendor to award a contract? So before we get into what makes a vendor non-responsible, it's important to point out that responsibility determinations are transactional in nature. This means that each contract requires its own independent VR review, and issues that may lead to a non-responsible finding can be different for each of them. With that being said, it's up to each state contracting entity to determine for themselves what types of issues can qualify for a vendor to be found non-responsible. You should be aware of the requirements of your transactions, such as certifications and licenses required to complete the work. The 4 VR factors of financial and organizational capacity, legal authority, integrity, and past performance can be helpful when evaluating vendors for responsibility. Some examples of issues that may lead to a non-responsible finding are fraud convictions, lacking proper legally required permits, embezzlement, and poor performance on state contracts. Always consider your own risk tolerances, as well as mitigating actions taken by the vendor to address issues they may have had, and be sure to follow your own internal policy and legal requirements such as due process when finding a vendor non-responsible. And that brings us to our next section, which is the vendor review resources section. Our first question here asks, What websites does OSC recommend utilizing for the vendor responsibility review? So the best place to find a list of websites you can utilize in your own VR reviews is actually right on the OSC website. If you navigate to the state vendor section and bring up the research vendor information page, you'll find a curated list of resources for each of those 4 VR factors, again, which was financial and organizational capacity, legal authority, integrity, and past performance, as well as a list of general resources that might not necessarily fit into those 4 VR factors. This page also provides you with a downloadable PDF that archives these resources and provides valuable information about them, including what those resources are used for and how you can navigate them. Some examples of these websites include the New York State Attorney General's press release website, the Workers' Compensation Board and Department of Labor debarment list website, and the New York State Department of State tax warrants notice system website. Moving on to our next question. We have limited resources and don't subscribe to a service like Accurate. Where can I find tax lien, litigation, and other information that the VenRep team utilizes for free on the internet? So for those of you who are not familiar with Accurate, it's a paid web service that acts as an information aggregate for various different pieces of information, including bankruptcies, liens, judgments, and corporate filings. However, there are several free public websites that we utilize at OSC to check for various financial and litigation relating issues. For New York State tax warrants, we recommend the previously mentioned New York State Department of State tax warrant notice system website. For federal liens in the form of UCC tax filings, we recommend the Department of State Corporations Financial Obligations website. However, be sure to note that this only lists UCC filings from within New York State. For vendors based outside of New York State, we recommend you search online for that particular state's Department of State website and look up their UCC filings that way. For websites giving information regarding litigation, the Attorney General's press release website and the United States Department of Justice press release website are excellent resources in addition to Google. We also strongly recommend you utilize the Department of Labor and Workers' Compensation Board debarment list website to ensure awardees are not currently debarred by either the Department of Labor or the Workers' Compensation Board. Next, we're going to take a look at a few websites that have undergone some recent changes. So there have been recent changes to the New York State Department of State Corporate Registration, the US GSA System for Award Management, or SAM site, and the New York State Department of Labor sites. How do we navigate through these to obtain the information we need? So first, we're going to take a look at the Department of State Corporate Registration site. So before we get into the details on this page, I first want to point out that this website works best in the internet browser of Internet Explorer. So for those of you who use different browsers such as Chrome, Firefox, or Microsoft Edge, you're going to struggle to get this website to operate correctly. So whenever searching this site, it's always best to use the Internet Explorer browser. With that being said, the first field I want to focus on is the entity name field. It's important to note that when using this website and searching for a vendor, the default way that this system works is it actually requires you to type out the vendor's name exactly as it appears within the database, meaning any vendors that have periods or hyphens or acronyms, etc. It's looking for you to type those out exactly, which can sometimes be difficult to figure out the correct pattern of a vendor's name. So our second section is called search functionality. I always recommend that you change that to the term contains. And what that allows you to do is then go back into that entity name search field. And instead of having to type out a vendor's name exactly as it appears in the database, you can use a shortened or truncated version of that vendor's name, and it should make your search a little easier. And lastly, I always recommend having all 4 options on the entity list checked off, regardless of the type of vendor you're looking for, just to give yourself the best chance to find the vendor that you're actually looking for. Next, we're going to take a look at the SAM website. So this has a similar search function, but it's a little bit different as to the way that you're going to want to search for your vendors. Instead of searching by a vendor's name, you're actually going to want to search by what's called a DUNS code or a DUNS number. For those of you who are unaware of what those are, it's simply a numeric code that's assigned to each vendor. If you're unsure what your vendor's DUNS code or DUNS number is, there's a couple different ways that you can find that out. First, it's often included in a vendor's questionnaire, or you can simply Google a vendor's name along with the term DUNS code or DUNS number, and you should find it that way. However, if those two options aren't successful, you can always navigate to the Dun & Bradstreet website, and they offer a free service where you can submit a vendor's name to them, and they'll send you an email back with that vendor's DUNS code. And once you have that number, just type that right into the search field, and if that vendor appears within this website's database, it should bring you directly to them. Next, we're going to take a look at a few pieces of information you can find using the SAM website. So the first piece of information you're going to find concerning your vendor, if they are in fact within the database, is whether or not they have an active status with the SAM website. Next, you can find out whether or not they have any debt subject to offset, meaning do they owe the federal government any money? And then finally, do they have any active exclusions, which are essentially federal debarments? I do want to point out that this website, while it is free to use, it is account-based. Now, you don't need to have an account to search, but if you search without an account or a login, you'll only be able to see the registration status of a vendor and whether or not they have any active exclusions. In order to access the information about debt subject to offset, you will need to set up an account with this site. For those of you who are interested in setting up an account, I recommend you reach out to your own internal organization just to ensure you have the proper authority to set up that account. Now we're going to move on to the New York State Department of Labor WARN website. So for those of you who are unfamiliar with the WARN website, the New York State Worker Adjustment and Retraining Notification Act requires businesses to give early warning of closings and layoffs, which are made public via this website. So when you first navigate to the WARN website, it's going to bring you right up to the current year of 2021 and provide you with a search field. When searching for vendors on this website, just like with the first site we went over, I recommend you don't actually search by the full version of your vendor's name, but instead a truncated or shortened version using maybe a keyword from that vendor's name. If that keyword appears in any vendor's names that have posted WARN notices for 2021, it'll navigate you to them and show you those results. Just make sure that you're actually looking at the vendor that you're working with because they might share a term in their name with another vendor. Just make sure you're looking at the correct one. At the bottom of the webpage, they provide you with links to past years going back to 2016. When you click on those, it's a little bit different way to search because you're not given that actual search field where you can type in a name. What you're going to have to do for those past years is either hit the Control F buttons on your keyboard or right-click anywhere within the website and select the Find function, and then you can type in that same term you used to search in 2021. And if that term appears in any vendor's names for those years, it should bring you right to them. Again, just confirm that any results you get are actually the vendor that you're looking for. Moving on, we're going to go to our next question, which asks, in our unit, we already check a vendor with a number of different agencies: OSHA, Department of State, SAM, Department of Labor, etc. Sometimes it can be difficult to identify the correct vendor using the search parameters. What suggestions can be made for more complete and accurate searches? So to start, we absolutely understand that it can sometimes be very difficult to conduct a review of a vendor. The first thing you can do if you're having difficulty finding what you're looking for is to search using different variations of the vendor or key employee's names. For example, some names contain acronyms or initials that can sometimes net better results if they're spelled out in their entirety. When using general resources such as Google, try using the advanced search feature and search for your subject against keywords such as lawsuit or violation. Cross-referencing information such as addresses you find in different resources can also help you narrow down results and help verify that you're looking at the correct vendor. Some other helpful tips is to put your subject in quotations so only exact matches are given, or putting the % or Shift-5 symbol in front of a keyword from a vendor or officer's name. This acts as what's called a wildcard search and should provide you with all the results that contain that keyword, even if that search field normally requires the order of words you search by to be precise. As an example, if you're looking for perhaps an officer of a vendor and you're not sure if you're getting the correct results, you could do that % or Shift-5 symbol and then type the officer's last name into that search field, and it should help you get more results that you can see to check to look up the correct officer for that vendor. And last, but certainly not least, if there are doubts about the accuracy of any information you've obtained, you should be able to contact the vendor directly to clear up any confusion, as they should be the ultimate authority on whether or not any information you've found pertains to them. Moving on to our last question in this section. Where would an agency find non-responsible vendor responsibility determinations? So this is actually a pretty easy question to answer. The Office of General Services maintains a website under their legal section with a list of vendors that have been determined non-responsible by various state contracting entities. When visiting this website, simply search by using the Control F or that right-click find function and search for your vendor's name. All state contracting entities should be communicating with OGS when issuing non-responsibility determinations, so this resource is up to date and comprehensive for everyone. And with that, that brings us to our next section of questions, which is our Workers' Compensation Board documentation requirements. And our first question in this section asks, what certificates are acceptable to submit as evidence of workers' compensation and disability benefits insurance coverage? So there are several different kinds of workers' compensation and disability forms you can submit as part of the required VR documentation for an award. For workers' compensation, we accept forms C-105.2 and the New York State Insurance Fund's U-26.3, which are both issued by the vendor's insurance carrier. For disability insurance, we accept the DB-120.1, which is also issued by the vendor's carrier. For self-insured vendors, we accept certificates of self-insurance, which are obtained directly from the Workers' Compensation Board. And for those vendors that claim an exemption from coverage, we require a CE-200 form, which the vendor can download from the Workers' Compensation Board website. They must designate a reason for their exemption, sign the attestation statement, and then submit the form to the state contracting entity for acceptance. These forms are valid for a period of 1 year after the printed date that's listed on them. We would also like to point out that accord forms are not an acceptable form of insurance proof and should not be submitted in lieu of the previously mentioned documents. Moving on to our second question. What workers' compensation forms are needed for subcontractors? Subcontractors absolutely have different workers' compensation and disability requirements than prime contractors, and thankfully they're very straightforward. Simply put, you are not required to submit workers' compensation and disability proofs for any subcontractors. However, as part of our review process, we do check the coverage of these vendors to ensure that they're in compliance with New York State insurance requirements. If we are unable to confirm if a subcontractor has applicable insurance coverage, we may reach out to you for clarification to ensure that they have the proper legal authority to do business within New York State, regardless if proof of coverage was required or not as part of the procurement record. Our next question asks, from time to time, we receive vendors' workers' compensation and/or disability proofs in a different name or FEIN from the contracted vendor's name and FEIN. As an agency, what should we do when this occurs? So per the Workers' Compensation Board, the name and FEIN listed on any workers' comp and disability proofs must match the name and FEIN listed on the contract exactly. If you experience this issue during one of your own awards, you should request a revised document with the correct matching information from the vendor. If there are any questions regarding this requirement, they should be directed to the Workers' Compensation Board. In the very rare case that these records do not need to match, written correspondence needs to be shared with us at OSC that confirms this determination by the Workers' Compensation Board. More often than not, however, this kind of discrepancy is a red flag that there are other issues at play with the award. The most common being that you're doing business with what's called a disregarded entity, which Vanessa Hartnett will give you more information on next. Thank you.
Thank you, Jamie. So we have received a couple agency questions regarding disregarded entities. Our first question being, what is a disregarded entity? So this is a separately incorporated subsidiary, typically an LLC, which does its financial reporting through its parent company. So for New York State contracting purposes, the disregarded entity is the vendor responsible for the contract, but all payments are made to the parent company for tax reporting purposes. On this next question, we will discuss what VR documentation is needed. So what vendor responsibility documentation is needed for disregarded entities? So when you're contracting with the disregarded entity, you will provide VR documentation for both the disregarded entity, who is considered the primary vendor, and for its parent company, who is treated as a subcontractor. So for the disregarded entity, you want to submit a responsibility profile, a VRQ if the contract award is $100,000 or more for the first time, and the workers' compensation and disability benefits coverage, since the primary vendor is responsible for coverage. And it's important to note here that the workers' compensation and disability coverage should be in the disregarded entity's name and actual FEIN, as the disregarded entity status does not change this requirement. And as for the parent company, whether they are performing work on the contract or just receiving state payments, they are treated as a subcontractor. So we need an agency profile and the VRQ on the parent company if they will receive $100,000 or more. And it's also worth noting that the process for creating vendor IDs, also called supplier IDs, for disregarded entities has changed. So when a vendor is identified as a disregarded entity, a new hybrid vendor ID will now be created. So this hybrid vendor ID will show the disregarded entity's name, but the parent company's FEIN. And transactions should be entered into SFS using this hybrid ID for state tax reporting purposes. So when you're completing the agency profile for a disregarded entity, you want to list the disregarded entity name, the hybrid vendor ID, and the parent FEIN in the header section of the form. You want to verify that this information matches the information on the contract record in SFS. And you also want to make OSC aware that the vendor is a disregarded entity. So on the profiles section, this is attachment A, the issues section, you want to make a note in the first line of the chart that the vendor is a disregarded entity and provide their actual FEIN. Then when it comes to the resolution section, you want to make a note that this is for administrative purposes only. Then when it comes to completing the profile for the parent, list them as a subcontractor and use the parent company's name, their actual vendor ID, and FEIN in the header. Now we will move on to our next topic. So we have received several questions on Vendor Responsibility Questionnaire, or VRQ. The VRQ is the disclosure that vendors can submit online or fill out via paper form. And this is required for any contract worth $100,000 or more for the first time. Our first question is, who has access to view the vendor's certified questionnaire? So once the vendor has certified their questionnaire on our secure VenRep system, you as the agency, along with any authorized personnel the vendor has granted access to, are able to review the questionnaire and read access only. And vendors can find detailed information about this VRQ access on the comptroller's website under the Vendor Responsibility section. So moving on to our next question, when is it appropriate for vendors to fill out the non-construction versus construction VRQ? And what's the difference between these two forms? So for this, you would want to consider the work scope and information your agency needs to determine vendor responsibility, especially if you're going to be using a paper VRQ. Vendors that perform actual construction activities are the target population for the construction VRQ, and related entities performing tasks like engineering and architecture would complete the non-construction VRQ. If the vendor uses the VenRep system online, it will determine which questionnaire is presented to the vendor based on the vendor's description of its business type and business activity. The difference between the construction and non-construction VRQ is that the construction questionnaire asks for information required by state's construction agencies. So this includes information on ownership, joint ventures, bonding capacity, past projects, and any current backlogs. So if this is the information you need in order to help make your vendor responsibility determination based upon the contract, then this is going to be the type of questionnaire you would want to use. The following slide is a question based on a scenario brought up by an agency. So I'm finding the 6-month requirement when online questionnaires are completed, but cannot find information on the OSC website for paper questionnaires. Are there different term requirements for paper VRQs as opposed to online certifications, or is it 6 months across the board? So the term requirements are the same for paper and online VRQs. We consider it current if it's within 6 months from when your agency requests it from the vendor. If the certification date is 1 year or more by the time it reaches OSC, we will ask for an updated VRQ. That being said, the vendor must ensure that the questionnaire reflects any material changes that have occurred since the vendor's answers to these questions were last certified. So if our VR team or you become aware of information that impacts the vendor's answers to these questions, the vendor will need to update their VRQ. And the main point is that vendor provides most recent information on their disclosure that will assist your agency in making a well-informed vendor responsibility determination. Our next question has to do with vendor name changes in the VenRep system. So will name changes made by the vendor in the vendor master file automatically update information on the online VRQ VenRep system? So it does not update automatically. After the vendor has completed the name change process through the self-service portal in SFS, the updated vendor data becomes available within the VenRep system after the vendor recertifies their questionnaire. This then triggers the update. The next question is in regards to certified VRQs. Can OSC make information available to the vendor population informing them that a certified VRQ does not mean the questionnaire has been reviewed and/or approved by the state contracting entity? So while there are no current plans to add this specific clarification, we do make our responsibility review process available to vendors via OSC's website, as well as the vendor welcome packet. The VenRep system page on OSC's site has noted reminders conveying the completion of the online VRQ does not automatically update and it does not automatically qualify the vendor for an award, and OSC does not receive the determination for this. So we recommend that when you are working with your vendors to remind them of the resources OSC has available to them, such as the OSC website, vendor welcome packet, and OSC's help desk. And the next question is, Is there a functionality within the online VenRep system that sends an automatic reminder to vendors when it's time to certify, recertify their online VRQ? So the system does not have this function, and it should also be noted that the agency process will dictate VRQ certification dates. So this is determined by whether the vendor has submitted a bid for an award per the state contracting agency's due dates. So we recommend vendors check their questionnaire status when they are responding to a solicitation or submitting a bid for an award. This allows them to update the VRQ to include their most recent pertinent information. And vendors are also required to update their questionnaire when there is significant disclosable information to report. So remember, vendor responsibility determination does not stop at the time of award, but it continues through the life of the contract. Moving on to our next question. Does OSC have a document repository for paper VRQs? If yes, can any state agency access it to view the vendor's VRQ for the next 12 months? So we do not have plans for a paper VRQ file that would be saved as part of the procurement record. Since each agency's process differs from one another, the vendor will need to update as required by your agency. We also recommend that vendors complete the online VRQ in the VenRep system, since it is easier and faster to revise their VRQ. Now we will move on to our next topic. So for this section, we've received several questions from agencies that didn't quite fall under the previous VR categories discussed at the beginning of the presentation, but these are important questions that we want to address. Our first question is, we have many exempt vendors, mostly counties, that subcontract with private or nonprofit vendors. What are the VR documentation requirements for these transactions, and would a profile for the subcontractor be needed? So prime vendors, such as municipalities, are typically exempt from VR document submission requirements. Agency profiles and vendor questionnaires are needed for subcontractors if subcontractors are known at the time of contract award, and it's anticipated that they'll receive $100,000 or more over the life of the contract. So while we don't require VR documents for subs receiving less than $100,000, we recommend that you perform responsibility reviews for all subs, regardless of the dollar amount. This will allow your agency to determine if the prime vendor's choice of subcontractor meets your agency's responsibility standards, and allow the vendor time to address any adverse information before the contract can proceed. And another question about documentation requirements deals with businesses not registered in New York State. Does a non-registered business in New York State need a certificate of good standing from where they are incorporated? So if a vendor has a physical presence in New York and is not exempt, then they should be actively registered with the Department of State. When you're dealing with out-of-state vendors, they should be registered and in good standing in their home state or state of incorporation. So if this is the case, then this is something you should verify. You can confirm this on any state's Department of State corporate registration search. Some agencies put this requirement on the vendors, making a certificate of good standing a required document for bid submission. And the VRQ requires that a vendor attaches their certificate of good standing if they are not registered in New York State. A reminder that VRQs are not OSC forms. They are forms that were generated from the New York State Procurement Council and New York State Council of Contracting Agencies, which were approved by state agencies. We have also received a few questions about responsibility determinations. Can a state agency contract with a vendor who was previously found non-responsible by another agency? So the short answer is yes, agencies can. However, this is a little more complicated in light of Executive Order 192, also known as EO 192. If after a thorough responsibility review, your agency determines that you wish to do business with the vendor for the contract being awarded, there is a process to get permission to proceed. So you're required to petition the Governor's Council and request a waiver for EO 192. You would then submit this waiver and the contracting agency's profile explaining how they assess all information, including the previous non-responsibility determination, with the transaction for OSC approval. Another question about responsibility determination: understanding that each agency must make their own independent determination. If a previous agency finds a vendor non-responsible and during the same month another agency is considering the vendor, what level of independent investigation and determination is required by that second agency? So as we just discussed, there is a process, and here's what to expect. You should complete a thorough independent review to support your agency's determination. And you want to keep in mind that responsibility determinations are transactional, and they're performed according to each agency's own processes and procedures. So non-responsible determinations may differ from agency to agency procurement, and you want to consider the impact the other agency's non-responsible finding has on your contract. And vendors who appear on OGS's non-responsible listing in accordance with EO 192 must obtain an approved waiver from the Governor's Council. And you need to include the waiver and assessment on the profile. And you can refer to the OGS website for more details on this. Our next question has to do with debarments. When can an agency contract with a vendor that has an active public work debarment? So, and what documentation is required? So based on the guidance provided, any vendor that is debarred by a New York State contracting entity is then debarred for all state agencies or authorities. Now, if the agency feels EO 192 does not apply to their situation, then they will need to explain why they can in light of EO 192. So this explanation should be part of your agency profile. Should an agency or authority proceed in this manner, we highly suggest involving legal staff when you're crafting your response. And it's worth noting that while an exclusion on the US SAM website is a federal debarment, these debarments are still treated as a public work debarment in New York State. Our next question has to deal with disqualified vendors. Has OSC disqualified any vendors for vendor responsibility? And where would this information be available to agencies? So OSC BOC does not determine a vendor's responsibility. It's based on your findings and assessment of the vendor if you determine that they are responsible. We may request additional information or documentation to help us understand your VR determination. And you can find debarred and non-responsible vendors on the OGS website and other resources found on OSC's website. Our last question is, Does OSC have any recommendations to assist an agency with obtaining information from the vendor on a timely basis? So while OSC cannot have contact with vendors in a procurement directly due to lobbying law, we do understand that there's only so much time to get the information needed for procurement to answer these questions. So if the vendor doesn't respond timely, you're left with limited options. You can set deadlines and, if necessary, find them to be non-responsive. If you do go this route, you want to be sure to document your agency's attempts to receive this information. And it's beneficial if you can establish a positive rapport with your vendors, and you can require or request the names of both primary and secondary vendor contacts. Now I will hand this over to Renee and Mia for live questions we have received during this presentation.
Thank you, Vanessa. Okay, Mia, before we start with the questions that were received in the chat, we did receive a few questions that weren't that were too late to make it into the presentation. So we're going to begin with those. The first one is, our agency has a contract pending with a municipality who is subcontracting with a large national or international business for contractual services. In my VR research, numerous lawsuits were revealed against this subcontractor, including fraudulent misrepresentation allegations, a 2011 discrimination lawsuit filed with the EEOC alleging racism, a 2021 class action lawsuit filed under the Employee Retirement Income Security Act, which was challenging the fiduciary's handling of a 401k plan, and a settlement to pay $4.3 million for underpaying overtime to hundreds of employees in 2013. First part of the question is, how would these issues be raised to the vendor? Then, are they to reveal the judgments of the case or the corrective actions resulting from the cases?
All right, good morning, everyone. Before I answer that question, I just want to reassure all of our attendees that the PowerPoint that contains the answers, as well as any links that we brought up during the presentation, they will be provided, soon after our fall conference. So I just wanted to make sure that you guys are aware that you're going to have something to refer to that has, more than just the questions that you got during or before the conference. All right, so to answer to this question, getting back to the question, so these are legitimate concerns that the agency or you want to address with the prime vendor. In this case, it's the municipalities, is the designated contact. So the prime vendor has the overall responsibility of the sub's performance. So notifying them of the issues you found is twofold. First, you're letting the prime vendor know of issues that you came up during your review that they may not be aware of. Okay. And second, it's going to allow them and afford them the opportunity to address these issues with your vendor, with the sub, that then they can go ahead and provide a response to you. And so you want any information, or you can ask any information that you need in order for you to make a solid, well-founded vendor responsibility determination. So that includes asking for the settlements and the status of judgments, as well as the steps the vendor may have taken to mitigate future occurrences. You want to provide, for them to provide you all the information that you need, to understand the issue, and also to understand what the vendor or the sub has done, and then for your agency to think about your own risk tolerances and if you can proceed with that vendor or not. So all questions are legitimate questions for you to go ahead to ask the prime vendor, who will then communicate directly to the sub.
The second part of the question is, are these lawsuits enough to ask the contracted municipality to seek another vendor?
I mean, you can have that discussion with your vendor, but first you want to consider, your agency standards and your review procedures. And like I said, your agency's risk tolerances. Remember, as Vanessa has mentioned, that these vendor responsibilities determinations are transactional, and you want to consider, do the issues that you found with this sub present concerns for that sub doing work for the contract that you're working on? You want to consider, how did that sub address those lawsuits or the judgments? Are they cooperative? Are they being cooperative in any investigations? Is there evidence of compliance or steps taken by the vendor to meet the obligations for any settlements? And after paying the settlements, did the vendor have the financial capacity to work on your contract? And also, like I said, you want to make sure that your agency feels comfortable going forward with the vendor in light of the information you received. And it's I strongly recommend that you document everything. You want to document your rationale as well, whether you're for proceeding with that sub, or if you're deciding to not go with that sub, you want to document any communication you have with your prime vendor.
Okay, thank you. We're going to move on to the next question. If a vendor does not have workers' compensation coverage, or if the coverage has lapsed and the vendor subsequently provides a current or updated certificate of coverage directly to me, is that acceptable to proceed with the VR process, or do we still need to wait until it appears on the Workers' Compensation Board's website?
Okay, we see this issue quite a bit, so we're aware that a delay may exist from when a vendor's workers' comp or DB coverage shows on the actual public workers' comp public site or their paid IC2 site. You should follow your agency's review process, but that being said, our VenRep team accepts copies of the vendor's workers' comp and DB insurance certificates to satisfy proof of coverage requirements, provided that the terms on the forms are current at the time that we are reviewing those forms, that the vendor's name noted is on the cert matches the one of the contract record. And so we do not require an agency wait until the coverage shows on the site. Current forms are acceptable.
Okay, thank you, Mia. The next question is, can my agency award a contract that is not grant related to a not-for-profit vendor who is not registered with Charities Reg?
Okay, so just to level set a little bit, Charities Reg is the registry of charities and fundraising professionals that maintains by the AG's Charities Bureau. And the Bureau is responsible for supervising not-for-profits to ensure that their funds and other property are devoted to charitable purposes and that they're used properly. So registration is required for all non-exempt not-for-profit vendors. So if the not-for-profit vendor isn't exempt from registering with the Charities Bureau because of their business classification, such as a religious organization, they are required to register no matter what type of work they'll be performing under the contract. Not-for-profits who are not exempt and who are not registered do not have the legal authority to do business in New York State. And more information on the AG's Charities Bureau requirements, including exempting vendors, can be found on their website. So that's the charitiesnewyorkstate.com.
Thank you, Mia. There's one more question in this section, and it's how does a disregarded entity get a vendor ID assigned to them?
All right. So your agency will facilitate the process of the disregarded entity obtaining its own vendor ID by sending an email to OSC's vendor management unit. And so the email address they would use, and we'll again include this in our second PowerPoint, is vmu@osc.ny.gov. So the email should explain the nature of the request, the relationship between the disregarded entity and the parent company, and provide the vendor's contact information. You also want to attach to the email a copy of the vendor's W-9. And so once the VMU creates the vendor ID, they will notify you, the agency, as well as the vendor contacts you identified in your email.
Okay, thank you, Mia. We're going to move on to the questions that we received in the chat. Is Wikipedia considered a reliable source for finding this information?
Okay, so Wikipedia is a great source to to start to learn or to get to know about your business. You can find about the vendors, how long they've been in business. You can find out key players, key officers information. So it's something that you can use as an additional resource. I know sometimes if I'm uncertain of the type of vendor that I'm reviewing, I will go ahead and I will just check out Wikipedia to see if I can find additional information about that business. Like I said, it's just one resource that you can use. Of course, the best resource, a business knows, the business should know what it does the best. So I also use the vendor's website as well. But yes, you can use Wikipedia.
Okay, moving on to the next question. What website do I go to find the vendor's DUNS number?
Okay. So that would be the Dun and Bradstreet website. You can find out information in addition to Wikipedia. Well, that one doesn't have the DUNS number. Dun and Bradstreet is an additional resource that you can find information about the vendor, including the DUNS number that you can use then to access the SAM site. That's Dun and Bradstreet.
Okay, next, I currently have a vendor that submitted a DB 120 with their policy number, but when I search on the New York State Workers' Compensation website, I could not find the vendor's name or policy. Is that normal?
It does happen. There can be a delay from when that vendor actually attained coverage from when it shows up on the actual site. If the cert is current and if you have the information on there that has, matches the vendor of record, that the FEIN associated with that vendor is correct, and you can verify that, and those forms come from the workers' comp. They're generated from the workers' comp board. So those are acceptable forms. So even if you don't see it on the site, as long as the form is valid and the information is correct and it matches the contract of record, you are okay to use that form and accept that as proof of disability coverage.
Okay, Mia, our next question is with respect to OSC's requirements, when is a VRQ required for revenue contracts or agreements?
Okay, so if the value is at 100,000 or more for the first time of the contract, VRQ is required for a revenue contract, just like with anything else. So it's not the particular contract, or, even though we're getting money, you're thinking, well, maybe, you're questioning why that could be the case. We're just checking to make sure that we want to make sure that whoever we're doing business with, and when I say we, I mean the state, that we're contracting with responsible vendors, no matter if we're receiving money, or sometimes it's not money, it could be land or a gift, or if we're spending the money. So we just want to make sure that we're contracting with responsible vendors, and the same rule applies. It's the $100,000 or more.
Thank you. Next up is, what about companies in foreign countries like Canada?
Okay. Same documentation requirements exist for the foreign vendors. Their vendors are going to we require them to disclose information about their business and about any type of potential adverse issues. And then you're going to need that information as, in part to make your responsibility determination for that vendor.
Okay, and next up we have, how far is the look back period for audits, including OMIG audits? Is it 3 years?
It's OSC typically says 3 years. And I believe that that is specified on the vendor responsibility questionnaire. However, I just can't state this as much enough that your agency has their own internal processes that sometimes can be a little bit more stringent than OSC's. So even if OSC says we typically go back 3 years, if your agency's processes is to go back longer than that 3 years time, that is, follow your agency's process. But as far as we go, we will generally talk about 3 years. And then keep in mind when we're talking about documenting the corrective actions that a vendor has taken to address some of those issues that were found during the audits, you want to consider the time when that issue was addressed. So if that audit was from 3 years ago, however, they did not start to address that issue until 2020, then you want to start from 2020 forward to report that issue as a disclosable issue. So it's not when the issue first came up. It is from when when the issue started to get resolved or has been resolved.
Okay, our next question. If your vendor has a current WCB but is debarred from Public Works, can an agency still contract with this entity?
So while Executive Order 192 allows for a waiver for non-responsible determinations, there is not a waiver available for debarments.
Okay, thank you. Our next question is, isn't Dun & Bradstreet a paid service, or is there a free component to look up the DUNS numbers?
You can access it there is a free component to that. I know that I've accessed Dun & Bradstreet just by Googling it, and then I was able to access and look up the particular vendor and search by the vendor's name and get the DUNS information.
Okay, and our next question, where on the OGS website is the list of non-responsible vendors?
Okay, Google is my friend, guys. We will definitely provide you the definite link, but what I do is I just Google OGS non-responsible list and it comes up. And like I said, it's going to give you a list of non-responsible vendors that's searchable, as well as you will get access or a link to the debarment site as well. And Greg has already put the link in there, which is ogs.ny.gov, debarred and non-responsible entities.
Okay, thank you, Mia and Greg. Next question is, if not appearing on the Workers' Compensation Board website, would we attach the workers' comp certificate to the VRP or keep it on file with a local agency?
So workers' comp certificates is part of the procurement record. If the contract or transaction is being submitted to OSC for review, so you're going to submit that workers' comp certificate as part of the procurement record. So yes, along with the VRP and everything else that you're going to send it in, whether it's electronically or if you're still sending it by paper documents, you're going to want to supply us that information. It's part of having a complete record.
Thank you. Our next question, when you say over $100,000 for the first time, what does the first time clause mean? We frequently grant to the same nonprofits year after year. I'm correct in thinking we have to do a vendor review each contract, right?
So yes, reviews are transactional. So when I say a first time, I'll give you an example. So you have a contract, and that contract, the initial contract is for $50,000. Okay. And even though you have to submit a profile, it has not reached that status of where you have to submit a VRQ. However, there comes an amendment that comes in for another $50,000. So that brings up that transaction value to $100,000. Now, even though this is not the first time that you're submitting a contract or, for that particular vendor and for this particular work, you're actually submitting it. This is your second submittal. This is an amendment. This is the first time that contract transaction is going to reach $100,000. So it's at that time that we are expecting that vendor, requiring that vendor to complete a vendor responsibility questionnaire and for you to submit that as part of the procurement record. However, if the transaction is $100,000 for the first time out the gate, yes, you're going to want to complete it then.
Okay, thank you. Mia, our next question has to do with foreign vendors. It's noted that they cannot provide workers' comp, disability, or an exemption. So Could you just explain what the process is for foreign vendors?
Okay, so we occasionally do get foreign vendor, we do work with foreign vendors. Workers' comp and DB, the Workers' Comp Board guides the information that is required for those type of vendors. The expectation is that if we do not get a certificate and they're not able to do a certificate for a valid reason, we're expecting an exemption. So evidence that these vendors, that foreign vendor is exempted from New York State's workers' comp or disability requirements. Now, the exemption form is a form that is not generated from the workers' comp. Basically, the vendors go onto the site, they go ahead and fill out questions, and based upon their questions, they can determine if they are truly indeed exempt from workers' comp. But our expectation is that we're either going to receive workers' comp certificates, disability certificates, or evidence of that exemption by that CE 200 form.
Thank you, Mia. And now the next question. Do third-tier contractors also require review? Are suppliers of materials handled differently than service providers?
So while OSC does not require agencies to provide vendor responsibility documentation on third-tier vendors, like subs of subs, your agency should be aware of the vendors involved in your contracts and follow your agency's process related to vendor responsibility. Material suppliers, if considered first-line subcontractors, would be treated as such for the purpose of vendor responsibility.
Thank you again, Mia.
You're welcome.
Okay, and our next question. It was our understanding from WBC OSC previously that if a vendor was debarred from public works, it was debarred from construction contracts, and an agency could still enter into a service contract with this vendor if they had a valid WC insurance and were working with WCB to clear up the reason for debarment. As once on the debarment list, the vendor cannot be removed for 1 year, and after the 1 year, even if the debarment reason is not cleared up, the vendor would be taken off the debarment list.
So this was the case previous to Executive Order 192. EO 182 does not allow waivers for debarments, regardless of work scope. Waivers are allowed for non-responsibility determinations. Detailed information about EO 192 requirements can be found on OGS's website. Is the IT service desk email still at the old or the new? So the IT service, the help desk email, that is the same that's currently on our site. So you should be able to get to the right person. And with the help desk, I just want to say is that should you have any question related to vendor responsibility or VMU, if you do contact the help desk, you're going to ask your question and you'll leave your contact information and a service ticket will be created. And that person, whoever gets that service ticket, they will go ahead and give it to the best unit to answer your question and someone will get back to you. The question is there a short-term format or process for OGS that has to go through pre-qualification in the grants gateway? I am not sure of that, and I will, but I'm going to just research that forward. And if I can provide the answer and some direction to that in our second PPT that will have the answers, I will be sure to do that. Thank you so much for that question. We have another question regarding 990. So it says also, why do IRS 990s not solely focus on negative net assets solely? They have a profile pushback for negative review and expenses, but positive net assets. I know that when we are looking at 990 financial information, we are looking at the losses and then the fund balance and if there are any diversion of assets. And so basically, you're not just looking at just that 1 year. I know for us, we're looking at trends, right? So we're looking at trends. So basically, yes, there may have been a positive, there might be a positive fund balance, or, but there may be room for cause and concern if annually that you're seeing that that fund balance is slowly dwindling because there are consecutive losses. So it might be something that you want to consider. If you're having a 5-year contract and then you're seeing that, okay, there's a substantial fund balance, however, there is a substantial loss, and the same thing happens for the next year and the next year, there may be cause for concern that, why is the vendor going to be able to perform the work on this contract in year 5 if it looks like they're losing money continually. So it's just something that you do want to go ahead to consider and to ask your vendor to assess it. Another question. So if after discussing issues or lawsuits with the prime vendor and they choose to seek another vendor, do we still need to complete a VRP on the vendor not chosen? So if we're talking about subs, I assume we're talking about subs. So remember, the prime vendor has the overall responsibility for that contract. They are the ones that are entering into a contract with the state. So if for some reason that prime vendor is not choosing to work with that sub, our expectation, we do not necessarily need to see a vendor responsibility review for the sub. I'm not going to tell you not to do it. Please follow your agency's process, and we will be happy to look at any information that you provide and that you have, documentation that you provide. But we are not, typically, we do not require for you to submit or to do an additional review for subs that are not chosen. Okay. I got some clarification on a short-term form. Tracy, thank you. She writes, in regarding Grants Gateway, there is no short form. The question is, would there be consideration for eliminating a VR if there is the Grants Gateway requirement? That I am not sure, Tracy. I know that there are just discussions going on regarding Grants Gateway and Grants Gateway requirements. I know there's internal discussions, not just with OSC, but I'm sure at other agencies as well. And I'm sure that, once more information becomes available, we're all going to find out. If there's any information that I can or I do find out, I will be more than willing to share, whether it's to you individually or if there's something that we at OSC can do to provide guidance or assistance guidance going forward. We will definitely do that. So we do have another question. If the vendor subcontract has been awarded over $100,000, then does the vendor have to provide a workers' comp certificate with the vendor responsibility questionnaire? So vendor, as I believe Jamie brought this up, but as a reminder, workers' comp and disability certificates, are we talking about certificates? They're not required for subcontractors. We may go ahead and, as part of our review, just to make sure that the vendor has the legal authority to make sure that they do have the proper coverages, but for that contract, subs are not required to have the workers' comp and disability insurance documents. Okay. So I want to look at this question again, and please forgive me for squinting. I'm just looking at the questions. Okay, so workers' comp and disability certificates requirements do not apply to subs regardless of their dollar amount. So I know that that $100,000 component is in there. Oh, I know why that $100,000 component is in there. It's because vendor responsibility profile is required in the questionnaire, is required to be submitted for subs if they are known at time of award, and that it's expected that that sub is going to earn $100,000 or more over the life of the contract. But that has nothing to do with the workers' comp or disability documents. One more question regarding what the vendor should be doing with those subs checking for workers' comp. So it says, but should the vendor be checking the subs contractors workers' comp? If that's part of the vendor's practices, and I would think that the vendor might want to see what type of protection that sub has to protect, as a protection of their business. However, that's not a requirement. We do not require the vendors or really have much say of what the vendors are checking off on their list and what subs is that they're going to accept. We have, our authority comes into making sure that we are going to not have contracts put in place that are dealing with non-responsible vendors, and we're talking about prime vendors as well. And with the sub vendors, since the workers' comp and disabilities coverage is not a requirement for us, we're not going to cause issue with that. The vendor may take it upon themselves to do that, but that's not an OSC requirement.
Okay, Mia, thank you. That was the end of our questions from the chat.
I just want to say, I want to just thank you again for your participation in this presentation. This is just an interesting way of doing things, right? With this new world of us being online like we are. But thank you for attending. And if you do have any additional questions or concerns, this is our contact information. Please do not hesitate to give us a call and to reach out to us. Thank you.